Hi everyone, my name is Alexander Zalivako, and I'm the founder of From A to Z law firm. One of the areas of our expertise are sanctions, and in a series of presentations called Sanctions 360 Degrees, we will look into major sanctions economic regimes and the way they affect the lives of private individuals and corporations. Thank you very much for watching. So we would look today into two cases which were recently considered by the UK Supreme Court. Those were two challenges brought to the UK sanctions designations. One by an individual who was designated as a person subject to an asset freeze, targeted financial sanctions in the UK, and the other related to the detention of a yacht in a London port. We would look into the key facts in both cases. Then we would discuss two key tests which were addressed by the court in the context of these matters. The first relates to the discretion of the executive in sanctions-related matters, what margin of appreciation would be given to the executive to make, change, or refuse revoking the designations. And then the keyer of the judgment and the keyer of challenging the designations under the UK sanction element, which is the satisfaction of the proportionality test, as a test which sets the balance between how far a public authority may go in restricting personal rights of individuals or companies while pursuing sanctions-related objectives. And we would conclude by what this case is likely to mean to any future challenge of sanctions designations in the UK. So there were two situations jointly addressed by the UK Supreme Court in the cases. One related to the individual designation of Mr. Shvidler, subject to asset freeze UK sanctions. By way of summary of the facts relevant for the analysis, Mr. Shvidler was a US-UK dual citizen, permanently resident in the UK for more than 10 years at the time of the designation. All his family was resident there. He left what was Soviet Union at that time at a very early stage of his life, and other than his long-term personal relationship and business relationship with Mr. Roman Abramovich and his non-executive board membership on one of the companies where Roman Abramovich was one of major shareholders, Yevraz, he had no, or at least the case revealed no other factual connection between him and Russia, both as a matter of any business relationship or any political kind of relationship. It's important to note that the way asset freeze designations occurred in the UK is that both Mr. Abramovich and Yevraz were designated in their own name. And once this occurred, Mr. Shvidler resigned as a non-executive director of Yevraz. It's important to note for the subsequent analysis and understanding of the case that he submitted his resignation before he was designated in his own name. As Mr. Shvidler is a British national, the effect of asset freeze sanction on him have no territorial limitation. So as far as UK law is concerned, and those jurisdictions which recognize the UK law would apply this restriction, all his assets worldwide are frozen, and no person can provide to him any funds or financial resources and in principle, regardless of the amount of the person who is providing the financial resource. So by way of example, his relatives or his children or his wife would be restricted from, for example, paying his utility bills, unless they can find a specific exemption in the regulation or obtain a specific license permitting to do that from the UK sanctioning authorities. So the point to make here is that for him as a British citizen, the scope of the restrictions was really draconian in nature. Mr. Shvidler, as it appears from the case, attempted to engage into a dialogue with the UK sanctioning authorities as to what steps, if any, he could take to be delisted. As these discussions proved to be unsuccessful, he filed an application for the judicial review of the decision on the basis that the restrictions which the sanctions imposed of him were disproportionate interference into his human rights under Article 8 of the European Convention on Human Rights, which relates to private and family life of an individual, and Article 1 to Protocol 1, which relates to the protection of property rights. The second case considered by the Supreme Court related to the detention of the yacht in the London port, where it arrived from the Netherlands, where the yacht was just constructed, for the purpose of participating in the super yachts exhibition arranged in the UK. Upon arrival, it was detained. It was actually the first detention of the kind at that time. And the important point to note is that the ultimate owner of this yacht was the Russian citizen, and there is a specific sanction provision in the UK sanctions regime which allows the detention of the vessels, including yachts, owned or controlled ultimately by Russian individuals to the extent such vessels arrive in the UK ports. The relevant Russian individual, according to the case, although a rich person, is not on any list of Forbes or any similar lists, has never been engaged into any political associations or politics in Russia. Similarly, he petitioned the relevant authorities for the removal of the detention instruction, which was refused. At least as far as his case is concerned, his main matter of complaint was the economic loss, which results from this detention, both with respect to the revenues, which he is not able to obtain by chartering yacht to various tourists during the tourist seasons, as well as the technical degradation of the yacht resulting from the yacht being permanently docked in a London port. So here the relevant legal argument was that this interference into his property rights, guaranteed under Article 1 of Protocol 1 to the European Convention on Human Rights, was disproportionate to the objectives which Russian sanctions purported to achieve in the UK. Prior to going into the judgment itself, it is worth making a very brief recollection of how the designation regime operates in the UK. The relevant provisions are set out in the Sanctions and Anti-Money Laundering Act, which in essence allows the relevant minister to adopt regulations with respect to specific sanctions regimes. As far as Russian sanctions regime is concerned, the minister can designate a person as subject to several Russian sanctions, out of which asset freeze would be the most comprehensive and the most draconian type of sanctions to the extent such person is an involved person. An involved person is also a defined term and includes various categories of persons. I give here the examples of just 4 of them out of multiple categories which go for several pages. And we can see that any person engaged in a strategic industry in Russia, which in essence can mean any type of industry, can be an involved person. And any person which derives economic benefit or other material benefit, so presumably economic benefit does not need to be material, can also be an involved person, which in principle means that any kind of foreign advisor to any meaningful Russian businessman can potentially be an involved person, or their family members. So with this in mind, it's also important to note that, as was the case of Mr. Shvidler, he actually resigned from a mining and extracting company with operations in Russian mining and extracting sector before his personal designation. So the connection of involved person also is indefinite in time, meaning that any past connection may be sufficient for designating the relevant individual by qualifying him as an involved person. Second point to note is that once a person is an involved person, he may be designated by the Secretary of State with respect to one of several UK sanctions which are available. And in our case, one of such persons was designated subject to the asset-free sanctions, and another was subject to the detention of his yacht. Once this designation occurs, there are in essence 2 options for the relevant person, apart from certainly engaging into discussions with the relevant sanction authorities, which both of the appellants in this case aim to do, but unsuccessfully. So the remaining 2 options would be, first of all, challenge that they satisfy the criteria of being an involved person, which is not the matter addressed in the judgment, but in principle unlikely to be successful given the breadth of the relevant categories which we just described. And the second is actually making an argument that the relevant restrictions imposed of them as a result of sanctions designations are disproportionate interference into their human rights. And on this basis, the decisions which resulted in this disproportionate interference are unlawful and shall be annulled by the courts. Another important preliminary question which was addressed in the judgment is the margin of appreciation or discretion, which will be accorded by the courts to the executive in their decision-making process. And here, whilst the courts acknowledged that it's for the courts and not for the executive in the context of the judicial review proceedings to form their independent view that the restrictions are proportionate or disproportionate and hence lawful or unlawful. So the judicial review process is not limited to checking whether procedurally the executive has arrived to a conclusion through a right process, but the substantive analysis of the matter. Nevertheless, substantial discretion will be granted to the executive branch, both in terms of the facts on which the executive branch relies while making the designations, and the actual appreciation of the relevance of those designations for the purpose of proportionality. And we would look into this in a bit more detail. Another important point, which gives substantial flexibility to executive, is that in assessing their decision-making process, the courts will take into account all evidence and all statements made by executive up until the hearing. So the judgment will not be based just on those assessments which were made at the time of the designation, but also, for example, by reference to the evidence brought in front of the court, which certainly gives substantial additional powers to the executive to bring up additional arguments all the way up until the actual hearings occur. So the core of the judgment actually relied to the following question. What would be deemed to be disproportionate interference into the human rights as a result of sanctions program to make a challenge to the relevant restrictions successful? And here the proportionality test, which was set by Lord Sumption in the Bank Mela case, was reaffirmed as a relevant test to apply. And it's a 4-part analysis requiring first to assess whether the relevant objective pursued by the executive is important. Second, whether the restrictions are connected to the achievement of that objective from the rational perspective. Third, whether the same objective may be achieved by less intrusive measures. And finally, whether the objective strikes a fair balance with the deprivation of human rights suffered by the relevant person. As to the importance of the objectives, which was the first element of the analysis, it was common ground that the objectives set by the UK government with respect to their sanctions program against Russia are certainly important. These are actually 2: to stop Russia from destabilizing Ukraine and threaten undermining its territorial integrity and sovereignty and independence. And second is actually to encourage compensation of the damage done to Ukraine. So these 2 objectives were classified by the Supreme Court as one of the most important objectives of the current British policy. There was no doubt as to this type of conclusion. What is important is that, in essence, the court stated that the more important the objective, the more discretion the government will have. So it's quite likely that, given the importance of the objective recognized by the UK Supreme Court, they would certainly grant a very substantial discretion to government in any similar cases going forward. Second point was the point of rational connection. And that was actually the main point of contention, because the main arguments of the appellants in both cases was that there is no rational connection between the restrictions imposed on them and Russia ceasing to destabilize Ukraine. The argument was made that even if we consider the totality of Russia's sanction program, so both appellants and effect accepted the point that the individual effect on them shall not be considered and analyzed in isolation, when it's very clear that this can have no effect on the Russian international politics, but shall be considered as a broad spectrum of sanctions imposed against Russia. So even within the context of the broad spectrum of sanctions imposed in Russia, the personal sanctions, which both of them are suffered, given the facts which we've discussed at the beginning, can have no effect whatsoever on the Russian foreign politics. Nevertheless, despite this argument, in essence, the UK Supreme Court found that there is a rational connection between both the detention of the yacht and the imposing of asset-free sanctions against Mr. Shvidler. As to the detention of the yacht, the connection was found to be both of economic and political nature. The economic connection was that Mr. Naumenko was deprived of certain income he expected to generate from chartering the yacht, as well as being in possession of the yacht as an item of prestige. And as to the political connection, the court deemed that putting pressure on the members of Russian financial elite could result in pressure on the Russian governing class and could result in the change of Russian foreign politics. In essence, the court supported the arguments of the rational connection which were brought up by the executive. In Mr. Shvidler's case, again, the rational connection was found in the sense that this would send a negative message to the Russian elite, and this would incentivize Mr. Shvidler to put pressure on Mr. Abramovich, who in turn would put pressure on the Russian governing circle to change the foreign policies of Russia. The third point, the less restrictive alternatives, was very briefly addressed by the court. It just said it's very clear that this limit is clearly satisfied. It seems that the analysis as to the least restrictive alternatives is unlikely to be ever successful unless the relevant measure is clearly irrational from the perspective of the objective which is pursued. So, in essence, the court will not engage into the discussion of whether there may be a better alternative or the alternative which strikes a fairer balance between the public objective and the rights of an individual, but would rather look into the question of whether the measure taken is clearly inadequate and is clearly not able to advance the objective. Final point of fairer balance. The court was very comfortable to reach a conclusion that Mr. Naumenko's rights, being the pure financial rights, cannot be considered as, in any case, overriding the public objective which the UK government wants to achieve as a result of its sanctions program. And it appears that pure economic rights would never be considered to be so unfairly restricted as not to justify the pursuit of the sanctions program. It seems that the hardship which has to be incurred is the hardship in terms of normal daily life, and given the presence of licenses as well as an opportunity to apply for a individual license even for those persons who are residing in the UK, would be very difficult to meet this threshold, let alone for those people like Mr. Naumenko who are not residing in the UK. For these persons, it seems that to the extent their issues relate to the economic personal losses, this would never constitute a successful challenge to the sanctions designations. In case of Mr. Shvidler, the situation was more complex because his adverse effect was not just about the immobilization of his financial assets within the UK, but was mostly argued on the basis of the effect on his private life, on the life of his family, who needed to immigrate from the UK, given the impossibility to live normal day-to-day life following the introduction of the financial freeze sanctions. So here one could think that the individual hardship in normal life standard could have been satisfied. Nevertheless, the court stated that the sanctions, to be effective, need to be as restrictive as possible. And given the importance of the objective, which the court recognized to be as one of the key objectives of the UK international politics, the fair balance was observed. So the question remains as to where this leaves us with respect of any attempt to challenge the UK sanctions designations following this judgment. The starting point to note is that, at least in case of Mr. Shvidler, the situation was really extreme. He seemed to have very little economic connection with Russia, no political engagement, and the effect of the asset freeze on his day-to-day life was substantial. Also, the arguments that by sanctioning him through pressure exercised on another sanctioned person, any change to the Russian politics may be achieved, seems objectively to be difficult to sustain. It seems also unclear following the judgment what the designated persons shall do, because to a certain extent, it seems that there is no way for them to avoid the restrictions following from the sanctions, which may create the incentives opposite to what the designation purported to achieve in the first place. Nevertheless, despite all these considerations, what's important to note is that the court made very little engagement into this type of discussion and into this type of challenging the facts of the executive, and the judgment, to a certain extent, merely accepts the executive's position, saying that that's sufficient for the purpose of satisfying the proportionality test, given the wide discretion which the courts shall allocate to executive in the matters of security and international relations. The conclusion seems to be that regardless of what type of facts and evidence the designated persons may bring into the circumstances, it's highly unlikely that, to the extent the executive maintains that the designation will contribute to the objectives pursued by the Russian sanctions policies, any such challenge would be successful, and or even that the courts would be willing to engage into an in-depth analysis of the relevant facts. With this in mind, it seems that the only way forward is, apart from certainly engaging into the discussion with the executive so that they voluntarily remove the relevant designations, would be to argue that the relevant person does not satisfy the criteria of being an involved person, which, as we briefly addressed at the beginning, is again unlikely to be successful given the scope of the definition being extremely broad, or the challenge has been related to clearly factual errors in text of designation. So, for example, about designations made on the basis of wrong identity or similar type of situations, which again normally would be presumably addressed through a day-to-day engagement with the executive. It seems that little scope is left following the judgment as to any other circumstances when the challenge to the designations may be successful. The remaining point to note is that certainly one would carefully watch whether this completion of the judicial review process within the UK will continue in the European Court of Human Rights, where both applicants in principle can file an application, and what the view of the European Court of Human Rights would be whether these type of restrictions arising from international economic sanctions are indeed proportionate restriction of their human rights given the objective pursued by them. I trust that you found this presentation useful. Thank you very much for watching, and hope to see you during my next presentations.